Welcome to this next edition of our CCIM Houston Gulf Coast webinar. We're kind of bummed we're not able to meet in person quite yet. Still hopeful that'll happen at some point later this year, but we are fortunate and excited to have Wilson Cribbs and Goren. Wilson Cribbs and Goren has three all-star attorneys that are joining us today: Leanne Karam, Tony Murray, Brian Kilpatrick, and they're going to discuss in kind of a panel type setting. So there's not going to be a slideshow or anything, more of an interactive type discussion on a lot of the issues that are very prevalent today, tenant issues, bankruptcy considerations, and just other various topics and items that are quite important to discuss during this very unique COVID time. So I'm going to just introduce each of the three attorneys here briefly, and then I'll turn it over to them. Tony Murray is a managing shareholder at Wilson Cribbs and Goren. He assists clients in the areas of acquisition, financing, construction, development, leasing, unimproved land, apartments, condominiums, office buildings, shopping centers, warehouses, industrial developments, and mixed-use products. He's board certified in commercial real estate law by the Board of Legal Specialization of the State Bar of Texas, and he's a native Houstonian, which helps him fully understand the competitive and rapidly evolving real estate landscape in Texas. He's a proud Aggie with a BBA from the Mays Business School and certificate in international business, and he's got a JD from the University of Houston Law Center. Leanne Karam has devoted her entire professional career to real estate. Most of her time is spent on transactions for the acquisition, leasing, and disposition of commercial properties throughout Texas. She's certified in commercial real estate law by the Texas Board of Legal Specialization and is listed as a Texas Rising Star super lawyer in 2018 and 19 by Texas Super Lawyer magazine. She also is a proud Aggie, BS in agribusiness from Texas A&M, and a JD from the South Texas College of Law. And last but not least, Brian Kilpatrick, who's a shareholder at WCG, assists clients with real estate, business, and bankruptcy litigation. He's been practicing law for more than a decade, joined Wilson Cribbs and Goren in 2015 to work with attorneys who share his passion of real estate law. He's been included in the list of super lawyers, rising stars for Houston since 2016, and was named to the Texas Verdicts Hall of Fame in 2012 and 2014. He has a BA from University of Texas and a JD from South Texas College of Law. So I wrote a little note here in the chat section. Feel free to type in any questions or topics throughout the presentation, and we'll do our best to hit everything we can within the hour. And I'll keep a lookout and keep track of those so that I can pitch anything directly to our panelists. So without further ado, I'm going to kind of slip into the background and let you guys take over. Thanks a lot for being here.
Appreciate you guys having us, and good morning to everyone. We have a lot of clients at the firm doing real estate transactions or involved in real estate litigation of different types. And I think that a lot of those clients are under the assumption that it's impossible for me to bill time before 9 a.m. or after 6 p.m. And so I get lots of phone calls during the early hours or the late hours with clients that just want to shoot the bull. And the thing that they're asking me, or the question that I hear over and over and over and over and over again, is, what are you guys seeing out there? I hear that question almost every day, whether it's a call just to ask that question, or if we have business to discuss, that question is coming at the end. They want to know what our law firm is seeing out in the market, whether it's in their product type specifically or something else. During a normal year, we'll have thousands of real estate transactions come through the office. And, so I guess to some extent, the thought is that we may be, have a broader perspective than others that are focused on one asset type. So what are you seeing out there? Have that question all the time. And, especially landlord clients these days are wanting to know, am I being treated the same by my tenants as other people are being treated by their tenants, or even the same tenant? What's around the corner? Is the pain over? Is it about to restart? what is everybody's attitude? How do they feel? Optimistic, pessimistic, opportunistic, pulling back, what is it? Well, to answer those questions, the first thing I say is it depends on the asset type. And our primary asset types that we deal with are retail, office, hospitality, industrial, and multifamily. Every one of those asset types, maybe hospitality is a bit of an exception. It's kind of an odd bird in that group. All of those asset types across my client base, I would say, have an eye toward recovery, meaning they've felt some pain at various levels. They've dealt with what they could, and they're trying to figure out how to move forward. They're trying not to stay stagnant. I've had, more deals go under contract in the last 2 weeks than I had in the 2 months before that. March, April, and May. So an eye toward recovery, but all on different timelines. So what's happening in retail is not at the same pace as what's happening in multifamily or industrial or office, and there's reasons for that. So where are the challenges in all these asset types? Well, hospitality has obvious challenges. Those are the challenges that, you don't have to be an expert in real estate to understand that there's challenges for hotels when conventions are being canceled, when people aren't traveling, people are opting to stay in rental houses instead of hotels and motels and condos. People don't want to get on elevators, things of that nature. So I'm not going to spend a lot of time on hospitality. Industrial, I would say that what we've seen is not a lot of disruption in the industrial market in terms of, not doing a ton of lease workouts or loan workouts, things of that nature, kind of distress type work in the industrial market. There's certainly industrial deals that we had moving that were put on pause for an extended period or were lost when the pandemic really came to bear on us at the end of March. But we have plenty of clients still developing industrial properties, putting land under contract, leasing industrial space. So industrial overall, I wouldn't say is one of the most impacted asset types in terms of what we're seeing come across our office. Multifamily. We have a large number of multifamily clients in various markets in different parts of the country. Multifamily is benefited by the fact that agency debt from Freddie Mac and Freddie Mae is a primary source of debt in the multifamily market, different from our other asset types. Freddie Mac and Fannie Mae were very quick to publish guidelines for forbearance on debt service, and many of our clients took advantage of those forbearance options as soon as they became available. Overall, I would say that our multifamily clients are seeing collection rates that are not as bad as they had initially anticipated in late March and April. And they feel like, depending on the jurisdiction they're in, that overall they're looking toward, are there opportunities for them to pick up new assets in the market? People that were buyers before are trying to be buyers again, and sellers are trying to be sellers. I don't know necessarily that's that enough time has passed that there was a big change in the bid ask on multifamily properties, but we are putting new deals under contract, both Class A, Class C, everywhere in between. So that's that's positive in terms of transaction volume in multifamily. All of that to say, multifamily has its own set of challenges to overcome. You know, multifamily is different than the other asset types that we mentioned because the tenants in those buildings are residents and they are living there. Those are their homes. So I have a contract right now that I'm negotiating where it's a 500 unit Class A apartment project. And as part of the bid requirements on the deal, the buyers had to confirm that they were willing to move forward in due diligence without having the opportunity to walk any occupied units. The seller did not want to have any risk with respect to people entering residents' homes, whether they had been tested or not, wearing masks or not, PPE, whatever you could think of. There was no situation where this institutional owner was willing to let somebody go into occupied units and allow them to walk around and do what would normally be a normal walkthrough, an opportunity for a buyer to be comfortable with the physical condition of the units of the property. Now, where the project is 90% occupied, that's a big change from what would be normal course of business for a sophisticated buyer who would most often have a property management type person, asset management type person, walking nearly all of those units looking for physical defects because, as everyone knows, the market standard is that these are as is, where is deals, and there are no representations based on the physical condition of these properties. Buyers are expected to do all of their own due diligence on physical condition during the due diligence period, and then after that, they're at risk. So having a multifamily transaction where the buyer has no opportunity to see the inside of what they're buying is very strange. It's not something I've ever been a part of before, and we're struggling to figure out how to make that work. The seller is not willing to provide any sort of representation whatsoever on the physical condition of units. And the buyer, although they're willing to enter due diligence without actually walking units, is struggling to assume the risk of literally buying a 500 unit apartment project blind as to interior condition. So multifamily has specific challenges, again, based primarily on the nature of the product and the fact that you have residents, hundreds and hundreds of them, living inside a pretty dense environment. With respect to office, at least in Houston, for us, didn't have far to fall. Had challenges certainly before the pandemic started. There's challenges afterwards. Our landlord clients are seeing their tenants benefit from the PPP program. Office tenants, just generally speaking, tend to be sophisticated enough to understand how the PPP program would work, that it's available to them. And so I think that office distress was certainly mitigated by that round of assistance from the federal government through that program. The most common issues that I'm seeing with respect to office properties is with respect to sanitizing and cleaning common areas and lobbies and elevator banks and all of that sort. So you're seeing 50-story office buildings where 2 people are allowed on an elevator at a time. And so there's long lines to get on the elevator. You're waiting for an extremely long period of time to get up to your office. So people are choosing just to stay home instead. And, what do you do when you have a tenant call you and say that there's a case positive in their office. What are your obligations as a landlord to disclose that to the other tenants in the building or other tenants on that floor? What actions do you take? There are limitations in terms of HIPAA laws about what you can disclose about medical conditions and infections and things of that nature. So, those are things that have never come up before, but are specific to office, and again, very challenging to navigate. And it's like many things that are coming across our desk, there is no bright line rule. So we just take, what we're seeing from other people and trying to craft best practices as best that we can, and trying to learn from, what other people in our office are doing and what other clients are doing. We are seeing a little activity in office leasing, which seems to be kind of a flight to quality. There's some businesses that are not at a distress level that they feel like they can't take advantage of some of the high quality space that's in the market that they can afford now that they probably couldn't afford before. So we are seeing leasing and subleasing activity in higher quality space. Also seeing a little bit of activity in sale leaseback with users that own real estate looking to generate cash for themselves and limit their exposure on their facilities. The big question for us that we haven't really seen answered yet is in the future, are these office tenants coming back? Are they going to be asking for less space? Are they going to be continuing to put more sublease space on the market? Or are they going to be using similar footprints but having less dense working environments? If you go into an architect's office, you'll see people shoulder to shoulder, working on different projects, moving around, changing workspaces, every other week, working with different people very closely. And that densification of the workspace is something that has been talked about frequently in the market for some time. And, maybe people start working more from home, but maybe their office space is less dense, and that in some way mitigates the impact of the work from home trend. The last asset type, and the one that we'll spend the most time on, is retail. And that's because retail has the longest list of challenges that we've seen, and we are spending the most time in our office working with our retail clients on a variety of different things. First of all, retail has a wide variety in terms of the tenant mix. You have service providers, dentists, doctors, restaurants, bars, mom and pop shops, national tenants, people selling all types of goods and services. And there's a level of unpredictability in government regulation as it relates to all of those different types of tenants that is making it very hard, I think, for people to make decisions. Meaning that day to day, week to week, depending on the jurisdiction, obviously, you have different orders coming at the local, county level, and then at the state level that affect different types of goods and services. Restaurants and bars have different restrictions than, a dentist or a doctor that are located in the same center. So there's sort of a quagmire of regulation that landlords are trying to kind of wade through in terms of understanding what they can expect from their tenants. We have seen the PPP program be very helpful in terms of tenants that qualify for that help in shopping centers to keep them going and allow them to keep paying their debts, their lease payments. Leanne and I have both been working on quite a lot of rent deferral agreements and lease amendments that relate to rent deferral and rent abatement arrangements. Again, most of our work is on the landlord side. So I will give Leanne an opportunity to tell us kind of what she's seeing in terms of rent deferrals, how those are structured, and some of the kind of conditions and considerations that our landlords are focused on when they enter into those types of arrangements.
Sure. So we actually had one national tenant that we were about to sign the lease at the beginning of March, and we're just putting on exhibits, and the pandemic hit, and we didn't hear from them until June. And when they came back, they said, hey, we're ready to sign in July, but we have a couple extra paragraphs we're going to add. And what came back was really broad language about, they went ahead and added in a rent deferment provision in the event that there's some sort of what they're calling a public health concern, which for them, everything was in the tenant's discretion. And for this tenant, they have a drive-through and a dining area. And if any part of the business closed, so if just the dining area closed, they could do the rent deferment, and it would last until they felt like it was safe to reopen. The rent deferment was for both base rent and additional rent. And if on the last day of the deferment period, they were not in default, the entire rent deferment amount was forgiven. So representing a landlord, we had to go back to this national tenant and tell them that we just didn't feel like it was marketable. And we asked for a few items, and luckily we got all of them. So what we were able to agree to is that it wasn't just their definition of a public health concern. It was an actual government order to close, and it had to be both, like the entire premises. So in our case, it had to be both the dining area and the drive-through would be closed. There was a specific endpoint that we agreed to rather than until they're ready to reopen. I think we originally started at 60 days and landed on 90. And we could only have this happen once every 3 years during the term. We tried to get it just once during the term, but it ended up agreeing on once every 3 years.
And let me just say, and I think Leanne would agree with this, it's pretty rare that we are negotiating a provision in a contract or a lease, you know, in the last 14 or 15 years that we've been practicing, that is a new provision, that's something, a concept that we've never seen before. And, you know, there's probably a lot of real estate lawyers out there that would admit to you after a few glasses of wine that they don't draft anything that hasn't been drafted before very often. You know, it's
That's
more
right.
of a variations of things that you've seen in different deals. And a client will say, well, this is kind of what I want to do on this deal or on this lease. And you think, you go through your memory bank and say, I remember seeing that in this other transaction from a few years ago. And so I'm going to go look at that. And I'm going to grab that provision and kind of work off of that. Very rarely are we working from a blank sheet of paper. And so what we're seeing now in the provisions that, like what Leanne is describing, is real estate lawyers working off a blank sheet of paper. And what they're doing is, after we've had this initial period with the pandemic and everybody, you know, pulled those leases out of their desk drawer, pulled the contracts out, you know, pulled the loan documents out, everybody is looking very closely at provisions that they didn't really pay that much attention to before. I mean, there's been whole seminars, many seminars on force majeure provisions. And so now everybody's trying to fill the holes that, it's not, they weren't even holes before, because it just wasn't a concept that was on anybody's mind to have a situation like this. So you're seeing a lot of new provisions. Leanne's example was from a lease. I'm seeing COVID or pandemic provisions in contracts that would allow for automatic extensions of closing periods or have extension of due diligence periods when inspections are not allowed to move forward in a timely manner because of inavailability of vendors to mobilize and things of that nature. So there's a lot of new concepts going around out there, and everybody is trying to figure out, what's market. And Leanne's example was with a national tenant. And certainly the first time when she showed me that provision, I couldn't believe it. I was it
was very well drafted. I will say I was impressed, although it wasn't workable for us, but
it was a strong
as a tenant, it's fantastic.
It was a strong ask on their part. And so they definitely started at one end of the spectrum. And so we're trying to pull them back toward the middle, or trying to understand what the middle is. And I think that's going to be a big challenge. And certainly with national tenants or institutional players in the market, they're going to have a bank of COVID or pandemic type provisions that they have batted around internally amongst their transactional lawyers and their litigators for quite some time before you even see it. And they're going to feel very strongly that they need those provisions in their contracts and their leases. And so it's going to be a big challenge working on the other side of the table with those folks, kind of to get deals done when you're looking at what they're asking for. And like Leanne said, a lot of times, this can affect the marketability of your project go forward. It can affect the underwriting on a loan. It can affect the way that the project is looked at by a potential buyer. It can affect the way that other national tenants view the viability of your project in terms of, co-tenancy clauses. If everybody has more flexibility in whether they stay open or operating or pay rent, is that a problem for the viability of the center where you have lots of national tenants with all of that flexibility? And what does that mean for the inline tenants that are relying on those national tenants being open? So that's a very big challenge working with these national tenants. They're going to have lots of new guidelines in terms of what they require in their leases. And so we're watching that very closely. One of the things that our retail clients want to know without exception is, am I being treated by client X the same way that client X is treating the other landlords? And you try and talk to as many friendly competitors as you can, see if they have the same tenant in their center, and they'll say, well, what is so-and-so doing? How is Ross treating their landlords? What's their protocol? And, it's no secret that a lot of the national tenants, when the lockdown was first happening, the initial reaction was, we're not paying anybody any rent, period. We're just going to stop. And there's even stuff floating around out there where landlords were saying, well, I heard that if you put this national tenant in default, you're going to go on a bad list, and that's going to be really bad. And so don't put them in default, and they're not going to reopen, or they're going to pay you last, or something terrible. And, I guess for some tenants, maybe that's true, maybe it's not. I feel personally that the landlords that I've seen have the most success did take a stronger approach to their national tenants than the ones that, I would say were, I say more understanding is a euphemism, But the ones that took a stronger, more aggressive approach with those national tenants, ultimately, I don't think I've seen that really hurt them in terms of getting those national tenants back to paying rent. I think from the national tenant perspective, I can understand if you have hundreds and hundreds of stores and you're trying to figure out in all these different jurisdictions with different orders about lockdowns and what's permitted and not permitted and what they can do and not do, I can understand why you might need to just have a blanket protocol that would say we're not paying rent until we figure this all out. And I think they're starting to figure out what the playing field is, and you're seeing national tenants be more responsive and come back to the table and try and figure out how to get caught up on rent and not really being penalized for what happened. I think landlords are happy to have them back, but there were a lot of national tenants that were put in default over the last couple months. Beyond just default, we've also had a wave of tenant bankruptcies. And I was going to let Brian talk a little bit about tenant bankruptcies, specifically in a retail setting. I think those are the ones that make the most news. I know there's been several recently, including Stage Stores, which owns Palais Royal, that have filed for Chapter 11 bankruptcy. And we have quite a few landlord clients that have at least one or more bankruptcies to deal with. And we kind of have a standard set of questions that we get from a landlord with a tenant in bankruptcy who's trying to figure out, you know, what are my rights in terms of collection? Am I going to get any rent? How long before they have to do something? Can I release the space? Can I, you know, sell all the stuff that's in the space? And, you know, how long am I going to be stuck with this thing? So, Brian, why don't you give us a little insight into tenant bankruptcies?
Okay, sure. So, yeah, we get a lot of the same questions every time there's a tenant who files bankruptcy, and you know, a majority of the tenants at this point have been retail tenants. And the first thing is, you know, what can I do? Can I lock out the tenant? Can I file a suit to evict? Can I do anything really? And generally speaking, the answer is no. And the reason for that is when a company files bankruptcy, there's what's called the automatic stay that is put in place immediately, whether you know about the bankruptcy or not. And what the automatic stay is basically an injunction, which means an order enforceable by the court that says you cannot go collect or take any action against the debtor to collect on, you know, what's owed or retake possession. So the purpose of it is to give a bankrupt debtor a breathing spell from creditors coming after him to try to collect. So if you have a tenant who files bankruptcy, do not send a note. That would also be a violation of the stay. So that's the most important thing to know when you have a tenant who files bankruptcy. The next thing is, well, what can I do after they file bankruptcy? Or
I think we may have lost Brian, Tony, and Leanne.
He's frozen. He looks like the deer right behind him.
Yeah.
Okay, so what Brian was saying was the automatic stay is a very powerful tool in bankruptcy to give the debtor, in this case a tenant, relief or a breather from the actions of creditors to collect on amounts owed. And so demand letters, lockouts, and other landlord type remedies are off the table when a tenant files Chapter 11 bankruptcy in this case. So there's Brian, you're back.
Okay, I'm back. Sorry, lost y'all for a second. So, so that's the main question we've been getting is, what can I do? And now I also want to go back and, if you have a tenant who hasn't filed yet, but you think is going to file. Can y'all hear me?
Off and on.
Cutting in and out a little bit.
Okay. Can y'all hear me now?
Yep.
Okay, sorry about that. So what I was saying is, if you think a tenant is about to file bankruptcy, we also get the question, is there something I should be doing to protect my interest or enhance my position once the bankruptcy has been filed? And there are some things that can be done. One thing is if you review the lease or have your attorney review the lease, because if there is a provision that grants the landlord a security interest in the debtor's property, you can file what's called a UCC financing statement, which basically perfects a lien on the tenant's property and then be treated as a secured creditor in the bankruptcy. Now, landlords already have what's called a statutory landlord's lien, but just by operation of law, but those liens can be set aside in bankruptcy. So if you don't have a UCC lien, you will be treated as an unsecured creditor in the bankruptcy, most likely, because usually the debtor will set aside that statutory lien. But if you have a UCC lien, that cannot be set aside unless there are some ways it can be if it was filed within 90 days of the bankruptcy, which is a lot of time. But if 90 days has passed after you file the UCC lien, then you should be in good shape as far as being treated as a secured creditor in the bankruptcy. Now, another thing is once you might consider, if the tenant is in default, you might consider terminating the lease before a bankruptcy is filed, because if you don't, then the debtor has 120 days after the bankruptcy is filed to decide whether to assume or reject your lease. So it really just depends on the circumstances, and several factors there to consider is whether you want to keep that lease in place, whether you think there's a good prospect of the tenant emerging from bankruptcy and staying in your space. But so if you don't think there's a good prospect of that, then, and you have another tenant, for example, who you could put into that space, then it's probably a good idea to terminate the lease before the bankruptcy is filed. Because again, once the bankruptcy is filed, you don't have that right to terminate. And the tenant gets 120 days to decide whether to assume or reject the lease. Now, the other thing is, if you lock the tenant out before bankruptcy, they can unwind that as well and get back into the space. Now, okay. So we had one question that came up from one of the viewers that if a location has good sales, why would a bankrupt tenant want to reject the lease? And that's a good question, because especially with national retailers, they look at all their store locations and sometimes part of what their bankruptcy plan and strategy is to reject the leases for all the poor the locations that are having poor sales or just aren't well, there's I guess a few different factors. Either their leases are above market, so they want to get out of those leases, or the sales at that store just aren't good, so they want to get out of those leases. So when you have the good locations, they generally will try to keep if the plan is to keep the business going as a going concern. So that's one strategy that a lot of retailers have, is to go through and reject all the bad locations and keep all the good locations. So to answer that question, generally speaking, a debtor who wants to continue as a going concern is not going to reject the locations that have good sales. And then a second question that came in was, can a tenant take a strong position if a bankrupt tenant, or can a landlord take a strong position if a bankrupt tenant wants to modify a lease? So what usually happens in a bankruptcy, when there are locations that the debtor wants to keep but wants to get a reduction in rent or something like that, there's a negotiation that will go on, and the landlord is not required to reduce the rent at all. I mean, the contract stays the way it is, and the landlord can insist on keeping it in place if the tenant wants to assume the lease. But if the tenant wants to threatens to reject the lease, that's some leverage that the tenant has to try to negotiate and a reduced rental amount. So really both sides have some levers. The landlord doesn't have to agree to anything, but the tenant has the right to reject the lease, and typically does say, okay, if you don't reduce the rent, then we're going to reject it. So that's just that is a negotiation that is very common in bankruptcies involving tenants. Now, okay, so on the subject of lease assumption and rejection, after the bankruptcy is filed, a tenant has, again, 120 days to assume or reject the lease. Now, during that 120-day period, if they're still in the space, they have to pay rent, again, on time every month. If the tenant does not pay rent on time, the landlord can file a motion with the court to get an order compelling the debtor to pay, and can also get the attorney's fees and costs associated with filing that motion. If the debtor ends up rejecting the lease, then the landlord gets what's called a lease rejection claim, which is basically a statutory formula, but generally speaking gives the landlord a claim for future rent up to of 1 year. And so of course that will be treated as an unsecured claim, and the landlord would get paid pro rata if and when there's a distribution made among all the creditors, all the unsecured creditors. Now, if the tenant fails to pay post-petition rent and then ultimately doesn't assume or reject the lease, the landlord has a higher priority claim for the post-petition rental period. It's called an administrative claim, and that is treated at the top of the payment waterfall. That is another advantage that landlords have in bankruptcy. Now, once the debtor has started to go through the process of assuming and rejecting leases, there can be situations where where the tenant isn't paying rent and the landlord isn't paying the post-petition rent, and the landlord wants to seek the relief it would be entitled to outside of bankruptcy. So one other option the landlord has in that instance is to file a motion with the court that would allow you to get out of pull your lease out of the bankruptcy, and it's called a motion for relief from the stay. And if the court grants that, then with respect to that particular lease, the landlord can go file an eviction sue for damages, do anything else that it would be entitled to outside of bankruptcy. So that's another option that a landlord has if the tenant isn't paying rent post-petition and is still occupying the space. And I know that I saw some other questions pop up. Someone asked, what is a Chapter 15 bankruptcy? Chapter 15 is those are very rarely filed, and it involves an international bankruptcy. It's an international bankruptcy procedure where there has been a bankruptcy or some type of receivership in another country, and they want to bring it to the United States. But it very rarely happens, and I've never been involved in one. But it does happen occasionally, and there are some pending right now that I've seen in Houston. But it's just basically it's a bankruptcy procedure that involves international companies that also have locations in the United States. Now, did we have any other questions that popped up that y'all want to address, Tony, Leanne?
No, I saw that one about Chapter 15. I didn't know the answer to that either.
Yeah, thanks for addressing that one. I didn't.
Yeah.
The other questions that have popped up throughout, and I know you guys touched on force majeure a little bit and specific provisions that have been popping up in leases that you've kind of had to adjust to on the fly. I mean, the specific question on force majeure was, have you seen success when that's invoked? I mean, what are the outcomes basically when that's invoked in a lease or a contract?
Well, we're mostly on the landlord side, and the vast majority of those force majeure provisions in leasing, in a leasing context, exclude the payment of rent from whatever the interruption is for. So even if you're able to kind of squeeze in square peg round hole pandemic, which is not typically a listed event in a force majeure clause, but if it's broad enough, you could put it in there. Even if you could fit it in there, it doesn't excuse the payment of rent the vast majority of the time. And even though there was an initial kind of wave of pushback from tenants trying to use the force majeure clause for some relief, I will tell you that a lot of the letters that I saw come from tenants explaining why they weren't going to pay rent did not reference a specific provision of the lease and didn't reference a case or anything. It was just, we're not going to be able to pay rent, and this is why. And we're just telling you why we're not paying rent. And so, it's very telling in terms of your position as a landlord when a tenant writes you a letter which is supposed to state a legal position, but they don't reference any support either in the lease or from somewhere else. So I'm kind of seeing that kind of stuff fade away. And I think that, again, with an eye toward recovery, you're starting to see landlords and tenants try and negotiate a business solution to the distress between the two parties, as opposed to fighting about whether or not the force majeure provision is really going to hold up or not.
Okay, thank you.
Yeah, and
no, go ahead, Brian.
I will say in the bankruptcies that we've seen recently, including stage stores, the debtor has, in almost all the pleadings that have been filed, made a reservation of rights to assert the force majeure clause of their leases. The COVID-19 pandemic and government orders for shutting down non-essential businesses, and it's yet to be seen how that's going to play out in the courts. I know that across the country there have been some courts who have held that the force majeure clause applies, and in other courts the they've held that it doesn't apply. So for one, it depends on what the force majeure clause says, because just saying there's a force majeure clause doesn't mean that it's going to apply to everything. It has to be specific about what is covered by that clause. And since a lot of these cases that are where tenants are raising that now haven't gone fully through the court system and resulted in final orders determining whether they apply or not, that's yet to be seen how the courts are going to treat those.
Okay, thanks.
So
I'm sorry, Tony, go ahead. I was just reaching out to the question.
Oh, I was going to say we're kind of getting short on time, so I wanted to make sure I wrap up. And if we have time to answer another question, we can definitely do that. Overall, to me, the biggest takeaway or summary of what is happening right now is we're seeing a lot of new language, new provisions, new concepts in contracts and leases of all different types that have not been used before. And, with the number of transactions that come through our office every day, we pride ourselves on having a really good understanding of quote, what's market, because you hear that thrown around a lot. Everybody says, well, that's not market. What you're asking for is not market. Market is this. I should know. I'm doing more deals than you, or whatever. Everybody is focused on, well, what's market? Well, I just really want to stress to everyone that we are truly in new territory on these concepts, and nobody has the authority to say what's market when it comes to some of these COVID and pandemic type provisions. And it's either going to be the landlords or the tenants that set the market on what these things look like going forward, because they're not going to go away. There will be some version of these provisions that end up in leases and contracts going forward. So knowing that there is no quote market provision right now tells us that somebody's going to set it, because it will be there. So it's going to be the landlords or the tenants. It's going to be the buyers or the sellers, the lenders or the borrowers. And it's all a matter of leverage, certainly, and timing, and what position you're in versus the person on the other side of the table. But you're not alone. Whatever position you're in as a landlord, a buyer, a seller, a borrower, lender, there are other people in your position, and we're all trying to figure out what's market and what is going to be the standard. But what we're seeing right now is that nobody really knows what it is. So these provisions are starting to come out. People are negotiating them, like Leanne said, gave that example of that provision that came from a national tenant. If that national tenant pushes that language out to 100 landlords and 99 of them accept it as is, well, guess what's going to be market for that national tenant going forward? You know what I mean? And if they get pushback from 90% of the landlords, then they're going to steer what's market in terms of that provision in a different way. And I think that even though everybody's in distress, we have to have our eye on as much distress that we're in. What are we doing to the marketability of our property? What is this going to look like to a buyer? What is it going to look like to a lender? And try to do no harm in terms of affecting, voluntarily, essentially affecting the pricing of your asset. So this is an important time in terms of what our contracts and such look like going forward, is how people take positions on these things. So Matt, I think we covered.
Yeah, one comment I would add.
We may have lost Brian again.
Yeah, well, it's going in. Can you all hear me?
Kind of, yeah, a little bit. Give it Give it another shot.
Okay. Okay, I'll give it a shot. One thing I would add is when you're negotiating forbearance agreements with tenants, some of those things I mentioned earlier, if your lease doesn't have a provision that grants the landlord a security interest in the debtor's property, put that in the forbearance agreement and add that so that, if there is a bankruptcy, you'll be treated as a secured creditor instead of an unsecured creditor. And, that just try to add anything that you would hope or wish you had in your lease originally. Try to get that in there so you're in a better position if there's a bankruptcy filed. But yeah, the key things that I would add are especially a UCC lien, because that really can enhance your position if the bankruptcy is filed.
Okay. I mean, we're almost out of time. I mean, my I guess personal question was on the retail side. I know that, closings have been kind of few and far between, but deals that have closed, I know lenders have required some sort of rent escrow. Do you guys think that are lenders going to require some sort of like pandemic reserve moving forward on like every deal in case we run into this situation again and tenants aren't paying rent? Which could obviously affect cash flow of owners, economics of a deal.
Yeah, so that's not just retail. Fannie Mae and Freddie Mac are also requiring debt service reserves on acquisitions and refinancing right now, and they're holding those reserves for looking like around 12 months. So, it doesn't surprise me that concept would bleed over into the retail space as well. And, it's hard to say that that's something that will just go on forever. It's gonna, if that is what's going to be required though, ultimately if that's happening long enough, it's going to affect pricing, because it's going to change the amount of equity that needs to be raised in order for a deal to get done. And so I am seeing buyers and borrowers starting to trying to figure out ways to deal with those requirements. But it is a requirement that we're seeing in a variety of asset types, not just retail. So I would expect that at least in the near term.
Okay. Well, thanks a lot, guys. I know we're right at noon. Thank you so much, Leanne, Tony, Brian, for donating your time, and got through pretty much, I think, almost every question. And everyone who's in attendance, thanks for being here. If you need to reach out to Leanne, Tony, or Brian, you can find their information on the Wilson, Cribbs & Goren website, or feel free to ping myself or Ginger. And I think this was recorded, so you may be able to rewatch it if you'd like to. I'm sure Ginger will send out a web kind of a link in a little newsletter that'll go out the next few days. But thanks a lot, guys. Really appreciate it. A lot of good information. You guys are awesome, and hope everyone stays safe and healthy and enjoys the summer, and maybe we'll all be able to get together at some point soon.
Same. Yeah. Thank you all very much.